Okay, good morning Year 12, and welcome back to another video based on what you should be doing in your time at home. This one's going to be the last one for a couple of weeks now, because if we were at school, it would be the Easter holidays after today, and so I'm not going to be doing any videos over the Easter holiday. Generally, I think you've got enough work to be doing anyway, because you've got the two 25-mark extract essays to do, and if you've not done your 9-marker by the end of today as well, you'll have to do that too. So you've got plenty to be getting on with over this time of Easter holidays. And if you want to contact me at all during that time, if you send me an email, I will pick it up within a couple of days, but I'm not going to be checking it every day, because I'm going to be having a holiday as well from my computer, because I'm almost fed up of looking at it now. Today I'm going to just finish off what we've been talking about with the Supreme Court. We've got a couple more lessons to do, because we need to compare the American Supreme Court to the UK Supreme Court, and we need to do a couple of follow-up questions on the Supreme Court, and then we've got to look at the civil rights question, which is the end of our Supreme Court kind of topic. So we've got a bit more time to spend on the Supreme Court, but this is kind of the last look at what the Supreme Court's been doing, and generally looking at the cases that the Supreme Court has looked at and all that kind of stuff. So today we're going to be talking about what the decisions of the Supreme Court has shown us about the Supreme Court itself, as in what can we learn about the Supreme Court based on the decisions that it's made over time. Now, we've gone through some of the main key decisions that the Supreme Court has made, but you do need to know a little bit more than the information that I gave you on that PowerPoint. That PowerPoint is for revision in the future and for jogging your memory, but there is a bit of extra detail that you'll need to know, and there is a lot of it. So what I'm going to do is I have taken pictures of the textbook on the knowledge that you need to know, and I've put it on this PowerPoint. If you've got a textbook, the page numbers are on the bottom of the pictures, so you can read it from the textbook if you want. But if you don't have a textbook, I think it's perfect now for you to go through each slide and read through what you need to know. If you can, make notes on it as well. Make notes of the key cases and what the cases have meant for each section. This could take you a long time, and I would expect it to take you about an hour or so, probably even more. So don't worry if this is something that you have to come back to on another day and you don't get a chance to watch the rest of this video straight away, because it's important that you know this. Generally, what I would do now is I would stop the video, I would go to this PowerPoint slide and I would read the pages, or go to your book and read the pages, and then come back to this video once you've finished that, because then what I'm going to do in the rest of this video is I'm going to summarize it for you. This summary is not enough information for you to know. You need to know the rest of it. I'm just summarizing what it tells us about the Supreme Court and how successful the Supreme Court has been. So you really, really do need to read through these pages. There's no cheats for this. There's no way of getting rid of this workload. You do actually need to go and read these. So I'm going to flick through them here. Look, so it's pages 189 all the way to page 203 that you need to know. So make sure you go away and read those, and then come back to this video. Okay, I'm assuming now that you have read it, and I'm going to be just summarizing it for you. So the question I'm asking is, what does all of this information tell us? Well, first of all, it tells us that the court's power over the judicial review enables it to interpret the Constitution. So there are a number of clauses of the Constitution which have been interpreted by the Supreme Court over the last few years. For example, in death penalty cases, the court interprets what cruel and unusual punishments means, which was written in 1791. Okay, but it needs updating to nowadays, because cruel and unusual punishments in 1791 were much different to cruel and unusual punishments now. For example, in 1791, in France, you had someone like Robespierre going around and guillotining everyone's heads off. And that wasn't seen as particularly cruel or unusual. Now, nowadays, even in France, going around and cutting people's heads off, it's not a great idea. And so we've changed our view on whether the death penalty is cruel and unusual, and some states have changed their view on whether the death penalty is cruel and unusual. So, as you can see, this interpretation of these words from the Constitution always needs updating, and the Supreme Court is that interpretation that America needs to function. Similarly, in abortion cases, they interpret the word liberty, which is in the 14th Amendment, which was written in 1865, and what that means today. Does a unborn child have liberty? Does it have a right to freedom? That's what they're interpreting. They are also interpreting phrases such as establishment of religion from the First Amendment in 1791, freedom of speech from the First Amendment in 1791, and the right to keep and bear arms in the Second Amendment. So, again, these have changed over time. The militias, the right to keep and bear arms that the Second Amendment protects, are possibly not possible now, and also wouldn't be effective now. And does that mean that because in the Second Amendment it was almost created so the militias would have the same power as the United States Army, does that mean that everyone has a right to nuclear weapons? And I think everyone has their own kind of opinion on that, but actually the Supreme Court is there to give a interpretation on what those words mean. So the court is not formally changing the words, they are just working out what the words mean today. Alright, and this is the main reason why America does not need to pass any formal amendments today, because if the Supreme Court is always interpreting these things and changing them based on what people believe the words mean, then it means that you don't need to make an amendment, you just need to make sure that the amendments that have already been created are interpreted in a modern way. Secondly, the court's power of judicial review turns it into a political institution. Because the Supreme Court makes decisions in policy areas that are politically and particularly contentious, it makes the Supreme Court, to a certain extent, a political institution. So that means that basically, even though it's supposed to be independent from the political spectrum and independent from politics itself, aside from the way that the people, I've forgotten the word, the justices, there we go, the way that the justices are nominated for the Supreme Court, aside from that, it's supposed to be kept free from politics. But the court makes decisions on such things as the death penalty, abortion, school prayers, and gun control, and loads more issues, which are key issues for both parties in America. And you can see a split down party lines on these issues. So therefore, any institution that makes decisions in these kinds of areas is bound to be seen as a political institution. And if they're making decisions that are seen to be against the Republican Party, for example, then the Republican Party is going to claim that the Supreme Court is too Democrat, too far down the other party's side. Similarly, it works the other way. If the Supreme Court is seen as going against the Democrat Party very often, they're going to claim that the Supreme Court is too Republican. And that makes the Supreme Court inherently a political institution. The court's power of judicial review also gives it quasi-legislative power. This is because the court's decisions have almost the same effect as if a piece of legislation has been passed. So in other countries such as the UK, laws on abortion rights, the death penalty and gun control all fall under the UK Parliament's control. So if the Parliament want to change our gun laws, all they have to do is put it through Parliament and get it written into the rule of law, and then it is a something that has been changed. It doesn't have to go through our UK Supreme Court. In fact, it never touches our UK Supreme Court unless someone launches a legal challenge against it. And so, therefore, in America, the judicial review that the Supreme Court has means that it has almost this legislative power where they can make a decision on something that then affects how laws are used in America. So, as I was saying, laws on abortion, death penalty, and gun control, and all other things that the Supreme Court looks at, are all covered in the Supreme Court in the USA. They're not covered at all in Congress or by the President unless they have a particular issue that they want to change. Finally, the Court's power of judicial review enables it to protect civil rights and liberties in today's America as well. All three branches of federal government have a role to play in protecting these rights and freedoms and guaranteeing these rights and freedoms that have been written into the Constitution since 1791. But this is particularly important for the Supreme Court as they have the power of judicial review to define what these rights and liberties are. So the court, as we were saying from before, is interpreting what these words mean. And so therefore they have a say on what these rights and liberties are. And the way you can assess how successful the Supreme Court's been on this is actually quite questionable. For example, due to Plessy versus Ferguson, segregation was legalized until 1954 and 1964, when it was finally eroded and got rid of in schools and the wider public respectively. Because it was only because of Brown versus Board of Education in 1954 and the Civil Rights Act, which went through Congress in 1964, that got rid of this segregation. The Supreme Court itself had allowed this segregation since 1890. Was it 1896? I think, which is Plessy versus Ferguson. Let me just look that up. I cannot remember. Oh no, that's not what I wanted to do. I want to make sure I'm correct. Don't want to get it wrong. While I'm doing that, though, other people would say that the court has failed to protect the rights of an unborn child as well, because they would say that abortion goes against the rights of that unborn child, and therefore, because the Supreme Court hasn't ruled particularly well on the rights of an unborn child, that they are allowing their rights to be impinged. It is 1896, by the way. Well done, me. So therefore, whether you think that the Supreme Court is successful or not successful, based on its protection of civil rights and liberties, is based on your view and your kind of position on the issues that the Supreme Court is ruling on. Okay, because one person's equality is another person's discrimination. And so there is a really long ongoing debate on whether the Supreme Court has actually been successful in its power of judicial review and in its judgments on a lot of the key policies of the Constitution. The reason why I'm telling you this, and the reason why I'm making a big thing about this point, is you may be asked this question in your exam, and you need to be prepared to argue based on what you know about the Supreme Court to say whether it has been successful or not. And you may be asked to compare it with the UK court and compare how successful each court has been. That kind of draws my information on this point to a close. As I said at the start of the video, I'm not going to be making another video now for a couple of weeks. And hopefully you've got plenty to be getting on with in those couple of weeks. If you need to contact me, please email me. I will check it relatively often, but it won't be every day. But if I pick it up, I will reply to you. And if you've got work that you want to send me to be marked, send it to me, but I won't be marking it probably until after the Easter holiday, because I think it's important to always have a break from these kinds of things at times. Thank you again for watching this video, Year 12. I hope you're all staying safe, and please let me know if you need anything, and I will help you with that. Goodbye.